isn't it? If it wants to come up, make sure YouTube's muted and. Yep.
Okay, Tiffany, you have audio now. Good job.
Thank you.
Let me rename you. It's Tiffany Holt, right?
Yes.
Okay. We're just waiting for the other attorneys to appear. So just go ahead and mute yourself, and as soon as they appear, we can put you in a breakout room, okay?
Okay. Thank you.
You're welcome. If I hit, okay, you know how to mute it yourself. There he goes. Okay, great. You have audio as well, right now?
Yes, thank you.
Oh, great. Okay, have you checked in? As soon as all the parties get here, it should just be a few minutes, okay?
All right.
And just go ahead and do you know how to mute yourself, Miguel?
Yeah, I think I do. Yep.
Just hit the button. Yeah, there you go. And Mr. Hurst, I have you checked in.
Okie dokie.
Judge, Heather has on base down at her desk right there next to you that Malachi could use.
Yeah, this is better because I can look at my screen here. We got anything ready, Michelle?
I believe we have all the parties on Hurst and Galinda's and yeah, just that one.
First is the plaintiff's name with an H.
Correct. Hurse, Robert. It's
All right.
232449.
That's good. Ms. Hurst, can you hear me all right?
Yep. Yes, sir, Your Honor.
Okay. And Galindez, can you hear me all right?
Yes, yes, sir.
All right. So what do we got scheduled today, Mr. Hurst?
Mr. Galanda set for a motion to certify the default judgment, and for the second time, objection to the motion for install payments and debtor exam follow-up.
All right. So, Mr. Galindez, you're filed a motion to set aside a default judgment?
Yes, sir.
Okay. Two questions I look at. One, did you have a good reason that the default was entered? In other words, if the default was entered because you failed to show up for court, what was your excuse for not showing up? The second question I look at is whether or not you have a meritorious defense to the underlying claim. You understand those questions?
Yes, sir.
All right. So why was the default entered? Did you miss a court date? Did you fail to file an answer?
Yes, sir. I missed the court date, and the court date was missed because the address was not correct on the paperwork. It was not sent to my home. I realized that. I went to the court. I rectified that. And from the very beginning, all of this started off with the address being wrong on the paperwork being issued by the bailiff, which came to my home. And he actually wrote down on here that he delivered it to the 48150 address, which is incorrect. And so they never corrected it when he came to my home at the beginning. So I never realized it. So I found that out. I
Okay,
went to court
let
and
me
got
stop
that.
you. Let me stop you. I want to make sure I understand. You received the summons and complaint from the court officer,
Yes.
correct? Okay.
Yes, sir.
And that had an incorrect address in the paperwork, correct?
In the paperwork, yes.
Okay, but you didn't correct that with the court until after you had missed your pretrial date?
I did not realize that the address was wrong because he dropped it off at my house. I wasn't looking at the address. I was looking at what was going on.
Okay, is that a yes to my
After-
question?
What's that?
Is that a yes to the question I asked?
No, that's a no, because I did not see it until after I found out about the court case. And then I went back and I looked at it and I realized.
So that's a
that the
yes.
address was
Sir, that's a
wrong.
yes. You
Okay,
did not correct the court with the address until after you missed your court date, correct?
Yes, yes, sir.
Okay, all right. When was the court date?
The court date was the 19th, I think it was.
August
Oh.
15th.
Hold on one second.
August 15th sound right, sir?
Yes, sir.
All right, when did you notify the court about your wrong address?
Probably like 4 or 5 days after that, maybe.
Okay, all right. And plaintiff tells me that this is the second time you filed a motion to set aside the default. Is that correct?
Well, yes, because the first time we did it.
I didn't ask you why, sir. I didn't ask you why.
Yes, sir.
Okay, when was that first motion heard?
At the last court case, at the last court
Which
date.
was when? You don't know when?
I got it here. Hold on one second.
Hirsch, you got it?
August 15th period.
That was on the 15th. The first
Yeah.
one was.
Find it.
Yep, that was August
I'm
15th.
sorry?
Yeah,
Yeah.
that was August 15th. The first one was 7/6.
All right,
Yeah.
so August 15th was the pretrial date you missed. The July date was the first time your motion to set aside default was heard, correct?
July 6th was the one that I missed. That was the one that I was supposed to appear in court.
All
Okay.
right, so what was
On
August
8
15th?
On 8/15 was the one that we did.
Mr. Galindez, you're making this much more difficult than it has to be because you're refusing to answer the questions as I asked them. My question is, what was scheduled the August date that you said you missed?
Jennifer, March, June, July. August was the date that we were supposed to do the hearing.
What hearing, sir?
The hearing for the judgment default.
All right, so what happened that it wasn't heard?
I didn't have all of the dates and everything, and I didn't have all my paperwork for the, noticing that the bailiff issued the paperwork to the wrong address and didn't correct it.
Okay. And what is, Mr. Hurst, what's this claim about?
A vehicle that I bought from Mr. Galanda's shuttle bus that I turned into a mobile boutique.
Oh, this is the mobile boutique one. Okay, I remember the facts on that one. Okay, thank you. All right.
And Your Honor, the address that he's talking about is the address that he gave me, and I looked it up through the county. He actually owns that property. He sold that property to somebody, and as of right now, he still shows that he's the owner of the property that the paperwork went to.
Okay.
Yeah, we heard this motion, but.
And yeah, we were with you with this whole case.
Okay. All right. So, Mr. Galindez, anything else about your failure to appear for the court date? You're muted. You're muted.
Okay, that is incorrect about the address. The address that was given to Robert Hurst was, I gave it to him originally when we very first started this, with the bus transaction. He knew what my address was.
Okay,
I don't
else?
know where he even got the address of my house being the 48150. That house has been sold since 2019.
But that's where the court officer served you and you received the summons and complaint, correct?
Incorrect.
Okay, but you received the summons and complaint prior
Yes.
to the court date that you missed in July
Yes.
or in August. Okay.
And that
All
was
right.
delivered to my home at 48184 Ware Road.
Okay, but you got the summons and complaint prior to the court date.
Yes.
Okay, and you didn't read the
No,
paperwork?
the original, that was the very first one. That was the first one that I received.
All right, you're confusing me. What was the first what that you received?
When it very first started, when the case started, that was the first one. It was delivered to my home.
Right, summons and complaint showing you that there was a lawsuit against you that was delivered by the court officer, correct?
Yes, sir.
And that was delivered prior to the court date that you missed, correct?
Yes, sir.
Okay, your motion to set aside the default judgment is denied. If you would have looked at your paperwork, you would have known in advance that they had a bad address, you could have contacted the court. What else is scheduled for today?
Your Honor, I don't feel that that's correct because I did
Mr.
not.
Galendez, you don't get to argue with me. You've given me your facts. I've made my decision. We're moving on. Is there anything else scheduled today?
Objection for the motion for installment payments.
Can you find any of that?
Mr. Galenda said he wanted to pay $200 per month, which would take 3 years to clear this balance. And when, going through all the finances and all that stuff, he had a extra balance of like $2,000 a month. So I figured we could do better than that.
Based on the finances that Mr. Galendez presented to you at the creditor's exam, it shows a disposable income of $2,000.
Yes.
Okay. Let's see if you can find his motion that he filed for installments. Mr. Galendez,
Yes, sir.
what do you have to say about that?
I don't have anything more to say because I'm like baffled over not being able to change this default judgment when the address was delivered to my home at the wrong address.
Okay, what part of you don't get to argue my decision don't you understand?
I feel like I'm being wronged here.
Then appeal me. Circuit court judges need work too.
It's not working. But
The fact that you didn't read the paperwork, I don't think is a good reason for you to miss a court date. That's all I'm gonna say on that.
Oh, I didn't hear you. I heard mumbling in the background. I'm sorry.
I've already made my decision. The fact that you did not read your paperwork and didn't catch the bad address is not a good reason for missing the court date.
But the paperwork was sent to the wrong
I'm
home.
not
I never
arguing with
received-
you, sir. I am not arguing with you. I have made my decision. I've explained my decision, and that's all I'm going to do on that.
Okay.
Is there anything you want to tell me before I make a decision on the installment payments?
Okay. From the beginning, there was a thing. The paperwork was not, it was filed for me doing work on the bus. And I don't agree with that either.
All right, sir. You filed a motion for installment payments on a judgment that I am not setting aside. That judgment is over $6,000. You've made a suggestion that you pay $200 per month. Mr. Hurst tells me that the paperwork you submitted for your credit exam shows a $2,000 a month disposable income. We're not going to talk about the judgment amount. We're going to talk about the paperwork you filed. Is there anything else you want me to talk about or no before I make a decision on the installment plan?
No.
Excuse me, Your Honor. That number came from just what he provided verbally. He didn't provide any paperwork. He wasn't like cooperative at the debtor exam.
Okay.
Afterwards, I was like, you can send it to the email. And he was like, yes, I'll do that. He didn't do that as well.
I mailed it.
Okay. You mailed it, emailed or
I
snail
mailed it
mailed?
to Roberts. I mailed it to Robert. Storm, here.
All right, your audio cut out. You mailed it as in
Yes.
through the postal service or you emailed it?
Yes.
All right, your motion for installment payments are denied. Anything else?
The debtor exam follow-up, because that was rescheduled after we did it.
Well, it
and
looks like we just lost Mr. Galindez.
I don't under.
What was, all right, what was scheduled for follow-up, Mr. Hurst?
It was just rescheduled on the debtor
What was
exam.
rescheduled? I'm sorry.
The debtor exam, it was on the
right.
like
All
follow-up.
right, so you have more questions for Mr. Galindez?
We just need the paper.
Yeah, we just need the paperwork.
Okay, I'm assuming you sent him a subpoena
Yes,
and it lists the documents that you requested
yes, sir.
and you did not receive those in the mail?
He
No,
wanted my social security number and everything, my bank account numbers and everything else.
I'm sorry, what about that?
He wanted my social security number, my bank accounts numbers and all of that
Yeah.
stuff.
Yeah, and he's entitled to those because he's got a judgment against you.
Okay.
And he tells me he asked you to send it by email and you decided to put them in the postal service, correct?
Yes, sir.
All right, so email them today.
All right.
Do you have the email address?
No.
Mr. Hurst, you know how to do the chat?
yeah, let me just click.
Or if you
Yeah,
don't have any problem just saying it, you can tell Mr. Galindez right now.
It's Robert at Hearst, my last name, .net. So Robert at Hearst.net.
Well, that's pretty simple. You got that, Mr. Galindez?
Yes, sir.
Anything else today, folks?
No, Your Honor.
Thank you. All right. Michelle, what file's next?
Thank you.
I have both the attorneys. I can't get Mr. Ivanchuk to respond to my chat, so I think they're ready. Mr. Ivanchuk and Ms. Prantazales, Concordia versus Watts.
Sorry, I was doing two things at once and didn't see the chat bubbles pop up. Sorry about that.
Give us the name again, Michelle. We're trying to find it.
Concordia versus Watts, it's 232886.
Give me the number again.
232886. Concordia is the plaintiff. Concordia
All right,
University.
we're still trying to find it. Let's have appearances, please.
Good morning, Your Honor. Melissa Pranzalis on behalf of the plaintiff.
John Ivanchuk on behalf of the defendant, who is also present, Your Honor.
Good morning. What do we got?
Your Honor, this is basically a collection action for unpaid tuition and other related expenses to the university.
All right, hold on, counsel. What did you tell me? Hey, Michelle,
Yes, sir.
I can't open that file because Mary Ann's got it open.
What? Oh,
That's what it says.
okay. Oh, let me call her.
Thanks. All right, counsel, I'm sorry. Go ahead. It's a collections action.
Yes, it's a collections action for basically unpaid tuition and other related
Yep.
educational expenses.
What's scheduled today?
Today it's
Pre-trial.
for a pretrial conference.
Okay. What do you two need from me? You need some discovery time? You need motions? What do you need?
Just some discovery time, Your Honor. The main issue here is that my client was receiving several scholarships for his attendance at Concordia, and it's just a matter of determining, making sure that the scholarships are properly credited as well as
Okay.
the tuition charges that were or claimed to have been incurred were
Okay.
actually for for classes my client was enrolled in.
How much time you need for discovery?
3 months probably work.
Counsel, that all right with you?
That's fine, Your Honor.
So why don't we just adjourn the pretrial for at least 90 days?
That's fine, Your Honor. In the meantime, it might be, or I didn't discuss this with counsel, but are Judge Martin or Judge Green available for mediation if necessary?
Yeah, we could do that. Sure.
Okay.
Sure. I'll
do you
leave it
want
to
me-
you two.
Okay.
I'm not even gonna deal with it at all. If you contact Judge Green, that should work.
Okay. I'll reach out to opposing
So-
counsel here after we get done and
Okay.
see if they'd be agreeable to it.
So what we're gonna do, I'm just gonna make a note in the file. We're gonna adjourn the pretrial for discovery, written discovery only. I'm assuming that's all right.
That's fine.
We'll schedule a pretrial after 90 days. And in the meantime, I'll leave it to you two. If you decide the informal mediation would be helpful, then you can contact Judge Green and schedule.
Thank you, Your Honor.
Thank you.
Anything else? You're welcome. Have a great day.
You
Thanks.
too.
Heather? Or, excuse me, Michelle?
Yep, I knew what you meant.
What's next?
I don't have all the parties on anything yet.
Okay.
Mr. Lucas wouldn't answer my chat either. Mr. Lucas, what case are you here for?
Good morning. It's Integrated Property Services versus Tiffany Holt. It's an 830 landlord tenant case.
Okay, great. Then we have both parties on that one, Judge.
And I'm sorry if I didn't catch your chat. I'm sorry about that.
Counsel, what's your plaintiff's name?
Integrated Property Services, LLC.
It's 23-00416.
Yeah, and that says Heather's got it open, so we can't open that file either.
I don't think I turned her on base off. Let me go check.
Thanks. All right, counsel, I'm sorry, your appearance for Integrated.
Joseph A. Lucas, P59595 for Integrated Property Services, LLC.
Thank you and good morning. Ms. Holt, can you unmute yourself, please?
Good
There you
morning,
go.
Your
Can
Honor.
you hear me okay?
Yes,
Good morning.
sir.
All right. Counsel, what do we got today?
Well, Your Honor, this is the third hearing. The last time we were in front of the court, there was a question about a payment that was made that I didn't show a credit on, but I do now. So I have due and owing $3,075 in rent, $219.80 in court costs, for a total of $3,969.80. That includes a $1,000 payment that Ms. Holt made. I believe it was later last month.
That payment
All
was
right.
made in September.
September.
And I just made another payment of $2,500 last night.
How
did you make that, Ms. Holt?
Here from Integrated Property to verify that. I'm not sure.
Through their
Okay.
Pay
Yep.
Now app at 7-Eleven.
I'm looking
Okay,
at the
so Ms.
ledger.
Holt-
Oh, I'm so sorry. I was just going to confirm that she did make the payment of the 2,500. I do see that here as of yesterday.
Thank you, Ms. Casco.
Of course, sorry.
So can we deduct that from the 39 number?
Yes.
So that would be a judgment amount of $1,469.80, correct?
That is correct.
According to my Casio. Ms. Holt, you agree to that number?
Yes, sir.
All
I
right.
get paid again on Friday. I was going to make another payment Friday. I was actually in the hospital from a heart attack during the last court appearance. I was literally in the hospital bed during that appearance. I've returned
you
to work
feeling?
and
Good,
I'm
good.
getting there. I'm back to
Okay.
work, so I'm trying to get caught back up with everything.
Sure.
I can make
Sure.
another payment on Friday, and then I can finish it out on December 8th, my next check, along with if not the entire December rent, a portion of it. I'm a seal home manager and we're getting our retention payments in December for the year. So I'll be able to get completely caught up once those payments are dispersed.
Let me make
But
sure,
I should, I'm sorry, Your Honor.
Hold on. I want to make sure I understood you because I'm not sure I did. You'll be able
Okay.
to pay the balance on the $1,469.80 plus get current with your December rent by December 8th.
I'm not sure that I'll be 100% by the 8th with December's rent, but I know that I'll have the rest of the balance paid off and as much as I can towards December's rent. Only because I am on a payment of the shut off notice with DTE and I've got to pay that so my lights don't get cut out.
Right.
But at no later than December 20th, everything will be caught up. December, whatever balance is owed for December, that would be my next check
Okay.
unless we get our retention payments before then.
Right. And how much can you pay this Friday?
This Friday, I'm not 100% sure. I'm gonna try to do at least 1,000, but I'm not 100% sure on what my check will be just yet.
Yeah, tell me what you know
Simply,
you can do.
I know for a fact I can do at least 800 Friday, but I want to try to do at least 1,000.
Okay. All right. But you know you can do 8 regardless of what your check looks like.
Yes, sir.
Okay. All right. Counselor, we got enough information that maybe you're comfortable doing a consent judgment?
I think so, Your Honor.
Can I throw you two into a breakout room to finalize that?
Sure, Your Honor, yes.
Is that all right? All
Can
right,
I
Ms.
be
Holt,
put in
you
there
okay
as
with
well?
that?
And Ms. Castro
Yes,
as
please.
well.
Thank you.
Yep. Hey, Michelle, Ms. Castro,
I got
Ms.
it.
Holt, and Mr. Lucas.
I'm
All right.
on
Good
it.
luck, folks. Thank you.
Thank
Thank you so much.
This man has something scheduled for live. He has something scheduled for Zoom.
You don't have anything scheduled for live for me.
Judge, I think Heather told me somebody was supposed to bring something in person to you and show you something today.
Oh. You know what? Yes, I remember this one now.
One showing the Zoom, one showing, you want to do it all on Zoom or you want to?
No,
Malachi, you
no,
should be able to
because
get that file now.
This
Could
one,
you get
the
it?
attorney was supposed to be here live too.
Okay.
Yeah.
I went into Heather's on base and completely shut it down. You're good now? Yeah.
Yes.
Yeah. So Heather,
Michelle, but I'm good.
I'm sorry.
That's okay. I'll just change
Jamie's
my name
throwing me
today.
off. Jamie's throwing me off because he's talking about Heather. All right. So on Discover versus Tyler, they're supposed to be live, and Tyler's here. Tyler's also got a hearing with Synchrony Bank that is Zoom. So if the attorney shows up for Synchrony, let me know. I'm going to have Mr. Tyler in my courtroom.
Okay.
All right.
Got
So when the attorney gets here from Discover, just send them in and I'll deal with them.
Okay.
All right. You want those? All right. We got anything else ready to go, Michelle?
I don't think so. Mr. Stuckroth? I don't see the other side. I don't see Miss Reed. He's
Yes,
here,
good
but
morning.
I don't see the defendant.
Counsel, how do you say the name? Stuckroth?
Stuckroth, very close.
Stuckroth. Good morning.
Good morning, Judge.
All right. You're scheduled at 8:30?
That's correct, Your Honor.
Okay. I don't do my defaults until after 30 minutes has passed, so we're getting there.
Understood.
Thank you. You know what? We're just killing time.
So Judge, I figured out, like, because Souther just had it up. So you have to completely exit out. That's why you guys couldn't access that,
Okay.
which is odd to me. So I didn't know two people can't have it up.
All right, now see this one. I gotta look at the motion in this file. So it should be related, right? that under home?
Yeah. Yep. Okay.
Did you get the number? I'm sorry.
Yeah.
Was it too quick? What court? What other court would we be doing? Can I go to some other court on it? Yeah, so what the hell? Motion, okay. So now I gotta go back to judge sign, back to home. Yes, sir.
Both parties are here. They're out there talking a little bit.
Beautiful.
And just want to let you know you have the dream team working with you today, Judge.
Beautiful. Oh, you're not covering us?
Don't mean you get me.
Oh,
It gets no better. Judge.
Why didn't I give me my signature option?
Try to go for justice.
No, it's supposed to be in the workflow. Judge sign. Primary viewer, inbox manager. Well, what the hell? I know you're not asking me, because you're supposed to be the expert.
Yeah.
Yeah, I just don't know.
The person who just joined us, Lisa Dukes,
Hello.
what case are you here for?
Lisa Dukes, Belleville Manor for Kristen Ridley.
Oh, are you the attorney?
No, I'm not, ma'am.
No.
No.
And do you guys see that file, that case?
We're doing some other stuff. We're going back.
Oh, sorry.
Which, that's all right. Which file?
She's the Belleville Manor, and the last name of the
Kristen
defendant is.
Kristen Ridley.
Are you Kristen Ridley?
No, she should be on shortly, ma'am.
That's why I can't
Okay,
find
who are
it.
you?
I'm Lisa Dukes.
Are you a tenant?
I am.
There you go. That makes sense. Okay,
Okay.
we'll get to you in a minute. Mr. Lucas, Ms. Holt, did you have any luck?
We have, Your Honor. We're all set for a conditional dismissal. Ms. Holt will have until December 12th to pay $1,469.80. The conditional dismissal will mean the case is dismissed. If she fails to make that payment by December 12th, we will be entitled to reinstate the case and immediately seek a writ of eviction. And everyone's agreed to that. Partial payment will not save the day.
Okay. Is your condition? I can't talk to it. Your conditional dismissal, is it going to cover the December rent at all?
No, we're not going to speak to that.
Okay. Okay. All right, Ms. Holt, you agree to that? You're muted.
Yes, Your Honor.
Okay. All right, counsel,
I
you're
am
going to submit the
authorized
paperwork then?
Yes, I will submit a consent judgment, or I'm sorry,
Okay.
a signed conditional dismissal. Ms. Holt has given me authority to sign on her behalf.
Beautiful.
So I can submit that from this office.
Okay. All right, great. Thank you very much. Ms.
Thank
Holt,
you.
good
Can I
luck with your
email
help.
that, Your Honor?
Thank you so
Yes.
very much.
What's the email?
Michelle
to
will
do it
chat
on
that
base.
to you.
Doesn't he have to do it on base?
Yeah, I guess he does, doesn't
You have to.
he? Yeah,
you
can
have
you
to
just do that through the on-base e-filing?
Oh, e-filing. Perfect. We'll do that. Will do. Thank you, everyone. Appreciate it.
Thank you.
Have a nice day.
You too,
Thanks,
sir.
Mr. Stuckroff. Can you find that file? Mr. Stuckroth, you there?
Yes, Judge, I'm here.
Thank you. Give me your plaintiff's name.
Of course, it's Foresight Finance versus Reed, 231408 GC. Attorney Stuckroth here for Foresight Finance, P85814. Good morning, Your Honor.
Thank you. And Ms. Reed still has not checked in, correct?
That is my understanding.
No, has not.
All right. According to my clock, it's 9 o'clock. Counsel, submit your default judgment.
As you wish, via fax, mail, or email, Your Honor.
On base, e-filing.
Understood. Thank you, Judge. Have a great day and a happy Thanksgiving.
You as well, counsel. Thank you.
Bye-bye.
Okay, Judge, we have Mr. Landman here for Levine, but we don't have the defendant yet.
All right, Mr. Landman, was that scheduled at 8:30 as well?
Your Honor, it was scheduled for 9 o'clock.
All right, so let's wait a few minutes. Thank you.
Thank you, Your Honor. Your Honor, by the way, I would note that the co-tenant is here. She's not the one that filed the motion.
Is that
but
Ms.
she
Dukes?
present.
Yes.
Thank you.
Yes.
Thank you. And counsel, what's the file number? So we'll pull that motion up so I can review it.
2300703 LT.
Thank you.
Thank you, Your Honor.
Can you find a motion? Yeah, so any idea why some are in one pile and some are in another? Yeah. Make yourself a note to bring that up with your boss, see if you guys can figure out what's going on with that, because it's terribly disjointed.
Okay, Judge, we have all parties on LVNV versus Carter.
LVNV versus Carter.
Yes, it's 232984. And then we also have Miss, where'd they go?
Miss Ridley.
We had, but I can't find her now. Do you Oh, here, Chris is trying again.
Mr. Landman, would you like a breakout room with Miss Dukes and Miss Ridley?
We can do that, Your Honor.
Sure. All right, we'll do that.
And Your Honor, if you can put the property manager in also.
Sure. Got that, Michelle? Can I have appearances on LVNV versus Carter?
What do I do?
Good morning, Your Honor. I'm Jack Francis on behalf of Plaintiff's Attorney of Record.
Good morning, counsel. Miss Carter, can you hear me okay?
Yes.
Good morning, ma'am. Miss Francis, what do we have?
Your Honor, this is a pre-trial today.
Miss Carter, a pre-trial is an opportunity for me to get some information about the file, hopefully so we can put it on the calendar and move it towards a resolution. Understood?
Okay.
All right. Miss Francis, would you like some time to talk to Miss Carter in a breakout room?
Yes, please, Judge.
All right, Michelle can make that happen. Miss Carter, we're going to throw you in a private room with Miss Francis.
Thank you.
Okay.
Did Jack just sign it? He's just lurking.
Are you talking about
That's your man,
Jack?
He just
I was trying to
he's
figure
just
out why
lurking.
Jack was here too.
Well, Malachi thinks he's just spying on me, but we're not sure.
Jack, why are you here? Look at he's not even responding to us.
Joe just thinks Jack misses the three of us. That's why he's on Zoom. He hasn't seen Joe for a couple of days.
He's ignoring us.
No, he sent us a chat. This just does not work. This does not work.
It's weird, like someone usually sensitive thing, but for some reason it's someone hearing out and someone in.
Well, in that one file said you were on it.
Yeah, and I'm not even.
Your on base isn't even open, is it?
It's open, but it's not on that case. So
I don't know if I can do 4 more years of it. Seriously. I don't think I can make 4. Yeah, I know better than that. You might have been a little bit confused, but not ever. She went home yesterday. She said, I'm just running home. Those guys are coming to bed. So she texted me at like 1:30 or 2. She's like, oh my God, I didn't realize it's going to take so much time. So she finally got back to it. And she said, I asked the guy what was taking so long. He said, well, I told your husband it would take at least 2 hours to do this. And she looked at me and she said, Scott didn't tell me that. Because, you know, they don't just come and take measures. They make templates, you know, they're doing install paragraphs. Of course. So they're making cardboard paper templates. Explain to Jack what the problem is there. You can start thinking on that. Oh. Hey, Jack.
Yes, sir.
Malachi's run into a problem with some of the folders or some of the files being in different folders. So
Okay.
he's going to explain it to you so you can start brainstorming it and hopefully we can figure out what's going on.
All right.
Hi, Jack. So
Hi, friend.
basically what's going on is usually all the files that are supposed to be heard today are supposed to get sent to the bench, but some of them are still stuck in the hearing docket.
Okay. If you give me the case numbers, I can try and figure it out.
For instance, 23, 29, 84
Joe.
GC. I can click off of it because I know that one just got sent over to a breakout room. I don't know if it was because it just didn't get I mean, it's not too big of an issue, but it's
I just sent that one to the bench.
I can route it there.
Yeah. So it should be in the bench folder.
Okay.
Thank you. Mr. Lamb, we're waiting for the ladies to come out of the breakout room.
That's fine.
Yeah, it's at 84. Remember they made those little Bronco tubes?
Oh, yeah.
Yeah. Morning.
Good morning.
I've been in this court since it was built. This is spectacular.
Thank you.
I'm really impressed.
Thank you. Thank you. Counsel, I'm trying to do on base. So it's all electronics. I don't have files anymore. So give me your case name.
Your Honor, it's 23703.
All right, thank you, Mr. Lehman. We'll get to you in just a minute.
Okay, thank you, Your Honor.
This case, 20-3821 GC, Discover Bank versus Jermaine Tyler.
All right.
Who stands to my left?
Yes, good morning, gentlemen.
Good morning.
All right, so I'm going back to memory. You were going to bring social security number to match, to show your card didn't match the number on their file, right?
I just gave him a copy of my social security card. We discussed it.
Okay.
It over. It doesn't match. I gave my ID and I told him that my date of birth, address, none of this
Right.
is my information. And he even gave my son's information. Gave my son ID and I showed him all.
None of that matches either.
None of that matches either.
Okay.
My son, 33 years old, his date of birth, that
Right.
court side.
Okay. All right.
Your Honor, do you want me to make my appearance for the record?
Oh, I'm sorry. Yeah, go ahead.
Good morning, Your Honor. Seth Golden, Counsel of Buckles and Buckles, attorney for today's hearing.
Thank you.
Limited appearance.
Thank you.
Your Honor, what Mr. Tyler is saying is correct in that our file carries a social security number and date of birth that do not match the social security card that I was just shown, nor does the date of birth. For instance, we're showing May 17th, 72 is the date of birth, and certain what's 17? June 17th. He's showing a month earlier on his license, etc. What is peculiar to us is, as we explained before,
Payment history.
Say it again.
Payment history.
Oh, the fact that it was open, the fact that the addresses all match addresses Mr. Tyler's lived at.
They don't match the address. None of them really lived at that.
Well, I was very much under the impression we had verified that already.
No.
It's our contention that the addresses do match his addresses in the past, and that there was a significant payment history. Usually fraud on an account is the kind of fraud where an account's open, or an account used, and then jettisoned, because why would a criminal pay back their debt?
Right.
Which made us wonder, well, even if there's some incorrect information, how likely, preponderance of the evidence, how likely is it that it was in fact fraud? Mr. Tyler has provided a lot of broad information. It is true he's filed a police report, but in the police report, he never brought his own driver's license in to follow up. It's true that he's stating he's the victim of multiple cases of fraud in his credit report. He has not brought his credit report. I don't have his credit report. I don't know if that's true or not.
Counsel, let me cut you off. And I'm going to apologize up front for cutting you off, but I made him a promise last time we were on Zoom. And I said, if you bring in a social security card that doesn't match, I'm setting aside your default judgment. We're going to go from there.
I understand.
And I'm nothing if not a guy that holds to my promises. So I'm setting aside the default, and let's get into all these other issues. Let's find out. All right.
So I'm so sorry, Honor.
That's all right.
Just to clarify. So my first argument was, my first point was to acknowledge the difference in these potentials. I'm not pretending otherwise.
Right.
Our concern was, does this particular account is it actually the result of a fraud or not? There were certain badges of certain factual elements
Counsel,
that did not make
that's
sense.
why I'm going to let him have a trial.
Right. But then we also had the procedure of
Counsel, I remember all your arguments. And I told him if the social security card didn't match, I'd set aside the default. I'm setting aside the default. We can get into all those other issues with motions, trial dates, wherever we go. You can argue all of that. I'm going to give him a chance to respond. That's all I want to do, is give him a chance to respond to this instead of sticking him with a default.
I can understand that, Your Honor.
All right. Then we're done. If you can understand that, then we're done, because I'm not going to have any more discussion. We're done. I'm setting aside his default. Now we can go to a pretrial.
I think we should conduct one now. We're here.
Okay, well, have a seat. Have a seat. I got a full Zoom docket. Have a seat. I'll get to you as soon as I get a break.
Thank you.
Yep. Michelle, what do you got? Are you ready, Ms. Francis, with Ms. Carter? Okay, you're muted. Tell me what we got.
Sorry, I was trying to get to the unmute. Your Honor, we have agreed to a consent judgment.
Beautiful. Tell me about it.
Defendant will pay $30 a month beginning December 10th and by the 10th of each month thereafter. The damages are $2,046.82 plus costs of $168.47 plus the $75 statutory attorney fee for a total of $2,230.29. And defendant has made 2 payments of $30 each already, which will be subtracted from that amount. And I believe Ms. Carter also gives us permission to sign the judgment so we can send it into the court.
Is that correct, Ms. Carter? Can Ms. Francis sign your name to that paperwork?
Yes.
All right. Do you have any questions, ma'am?
No.
Okay. All right. Have a good day, Ms. Carter. Ms. Francis, you got any other files today?
I'm done. Am I done?
You're all done, ma'am.
Thank you.
Thank you.
You're welcome.
Yes, Your Honor, I have Synchrony Bank versus Jermaine Tyler.
Oh, you know what? He's actually in. He's actually in the building. I've got him live on another hearing, and I can throw him into a Zoom room when I'm done with this one, so you can talk to him.
Okay.
Okay. Mr. Landman, I think we lost our tenants. There must
Yeah,
be
I'm
stuck
trying
in
to get them out.
breakout room.
I'm trying to get them to come out, Judge.
Okay.
If I have to,
All right. I'm going to go back to my live hearing. All right. So, Mr. Tyler, a pre-trial is an opportunity for me to get information about the file, which I've got a lot of on this just because of all our conversations. So hopefully we can put it on a calendar and move it towards a resolution. Understood? Discovery?
So, Your Honor, briefly, if I'm to address the procedure, the defendant indicated, I think multiple times, it's his own motion that he's seeking to elect for arbitration under the agreement. Is that correct?
I didn't remember that, so.
Oh, I did file a motion previously to.
Okay.
You stating that you were gonna set aside, because I read that at any time I can elect for arbitration in the matter.
All right. Are you making that request now?
Yes, I'm making that request now to dismiss. It was to dismiss the proceedings and proceed if they were going to
go to arbitration.
Yeah.
Okay. Any response to that?
Yes, Your Honor. So our position is that we would think it reasonable to stay this case or to give defendant 30 days to initiate his arbitration. And if he doesn't, then the case would proceed before this court, because it's elective arbitration.
Right.
And if he's going to do it, then he needs to do it right away. And if he's not going to do it, then we should proceed before his honor. If we're going to continue in this court, then we would seek discovery.
Sure.
I would think 60 days.
Let me stop you right there.
Sure.
You're planning on filing the arbitration request?
I think that was prior to me asking to.
No, I understand, but as of right now, with the reality we're in, do you want to arbitrate or do you want to go forward with the court case?
At this moment, I want to go forward with the court case.
Okay.
I decide later that I'll exercise, because I was understanding in arbitration that once I elected to dismiss it, that if they were the ones who had to pursue the arbitration and
I don't think so. I think either party can request the arbitration, correct?
Your Honor, it's elective. If defendant wants to arbitrate, then we've done, under the contract, I believe he has the right to do so since the judgment's been vacated.
Right.
I mean, it's one or the other. I mean,
Right.
I feel like the defendant's being cagey here. If he wants to arbitrate, then the court should hold him to 30 days to do so.
Mm-hmm.
And if he doesn't initiate arbitration and show proof of that to the court so as to stay this case pending the results of arbitration, then this case should proceed.
I think that's reasonable.
Your Honor, it is my understanding that I had the right to, either one of the parties had the right to assert arbitration at any time.
Right.
But the assertion was on the burden was on the one who asserted the allegations and not me. The burden went on me to.
No, I don't believe that's the case. I don't believe just because you didn't bring the claim.
I did cite some case law that I have found.
Well, here, I'm going to go along with his suggestion. All right. Because I want you to understand, this isn't in any time, right?
Mm-hmm.
So if we go through the court process and I enter a judgment, you don't get to, I'm going to go to arbitration. At that point, there's a judgment. Mm-hmm. Understood? Mm-hmm. Is that a yes?
Yes, yeah. You
Okay.
said, okay, so,
All right.
okay, but,
So I'm gonna go along with that suggestion. I'm gonna give you 30 days to start the arbitration process and show that it started, and then we'll just put this case on ice. But if in 30 days you haven't started the arbitration process, then I'm gonna open up the 60-day discovery period that council's asking for. Understood?
okay, yeah, okay, but John, I just want to object to you because, like I say, from the case law, that from my understanding,
Right.
is that either party can assert the arbitration, and that it was on the party who was pursuing the case who responsible for filing the arbitration with AAA or one of the arbitration hearing places. I have read the information thoroughly. It could be.
And I don't agree with you. You can appeal my decision. That's fine. You're not gonna hurt my feelings if you appeal my decision to the circuit court. My order is, I'm gonna give you 30 days to start the arbitration and document it. I'm gonna put this case on ice until then.
Okay.
If you arbitrate, if the arbitration process starts, we'll wait and see what happens with it. If you don't get it started within 30 days, at that point, we're gonna get this case back on the calendar.
Okay.
Clear?
Clear.
Okay. Anything else?
Your Honor, so 60 days, if we wind up here, and just to continue
Yeah.
the pretrial, 60 days discovery. Your Honor, I don't see any point in mediation if we are to continue. Plaintiff's going to seek.
I don't do mediation unless it's an agreement.
And plaintiff, I'm sure, would like to reserve a date for a summary disposition motion.
Sure. We're not making any of those decisions now. We're gonna do if we get to that, we're gonna do the discovery and then we'll see where we go from there.
Okay, Your Honor.
Okay?
I appreciate your time.
Would you prepare an order to that effect
Yes.
and send it to us on base?
Yes, so being here of counsel, I can communicate.
Well, yeah. Will you have somebody prepare an order
I
for
can
it?
communicate
All right.
the order and we
Okay.
can go from there. Or if the court would like, I could handwrite one now, have it approved.
Your call. Your call. That's fine. He's gonna be around for a minute because we gotta put him on Zoom with another case.
Okay, so it says my understanding, Your Honor, that you are vacating and setting aside
The default judgment set aside.
You stand it until arbitration is complete. You stand the judgment.
No. I'm setting aside the judgment.
Set aside the judgment, but
The judgment didn't happen.
you stand the proceedings until.
I'm staying the proceedings first for 30 days
For
to
30
see if the arbitration gets started.
Okay.
If it does, then we're just gonna let the arbitration run its course before we do anything here.
Great.
Right? If you don't get it started, then we're gonna get back on track and we're gonna start, once we're on track, with 60 days of discovery period.
Okay.
Okay? Clear?
Clear.
All right. Joe, can we get Mr. Tyler back downstairs, get him in Zoom so he can talk to Ms. Francis on that other case?
Yeah.
All right. So if you go with the court officer, but don't leave yet. Are you gonna do a hand order, counsel?
Yes, Your Honor. Well, I thought I might do this. I thought I might read the order into the record based on what I write down. And if we
Okay.
prove it right now, then I could just have
Okay.
an order.
Okay.
submitted today.
So don't leave yet. Just give me a minute. We're gonna put that on the record. Mr. Landman, are you ready on Ridley?
Yes, Your Honor.
All right. So if I understand correctly, Miss Ridley, good morning, Miss Ridley, you're muted.
Good morning.
All right, Miss Ridley, can you hear me?
Yes.
Okay, so I looked at your motion. If I understand correctly, you filed a motion to set aside a default judgment because you did not have notice of the underlying lawsuit until after you missed a court case, correct?
Correct.
Okay, and your justification for that is because you don't live in the unit, Miss Dukes does. Miss Dukes received the paperwork for service of process, but you did not receive that. Am I summarizing correctly?
That's correct.
All right. So when I look at a motion to set aside a default judgment, there are two questions I look at. One, do you have a good excuse that you missed whatever deadline you missed? And this case, you didn't show up in court. The second question I look at is what's your underlying defense to the claim against you? Understood?
Yes.
Okay. And Mr. Lehman, I'm assuming this is a non-payment of rent case?
That's correct, Your Honor.
All right. And Mr. Lehman, are both ladies on the lease?
Both ladies are on the lease. Ms. Dukes is an authorized occupant.
Thank you. All right. So, and Mr. Lehman, what's your number right now as far as outstanding rental?
Your Honor, the outstanding balance as of today is $6,324.37.
Okay. And Ms. Ridley, what's your defense to that unpaid rent?
Well, the funds are available to pay.
I'm sorry,
Ms.
did you say they
Dukes?
are or are not available?
They are available to pay.
Okay. All right, so does that mean you agree that you owe that?
Yes.
Okay, all right. Mr. Lambert, did you discuss a consent judgment with the ladies?
Your Honor, at this point, this is a situation where, since the ladies moved in the spring, it has been one problem after another collecting rent. There have been payments returned to NSF. The balance has steadily increased. Back in June, the balance was 2,000 and change. It has steadily gone up. And quite frankly, my client at this point in time would simply like to have an amicable divorce and have these tenants vacate.
All right, so this is not a non-payment of rent?
No, it
This
isn't. It is a
determination?
non-payment of rent case. They didn't have the rent at the time the judgment was entered. The order of eviction was actually submitted to the court and put on hold because the motion to set aside the default judgment was filed in the interim. I'm not sure that, quite frankly, that the tenants satisfy either prong of the test to set aside the judgment. The fact that Ms.
Maybe
Dukes,
the first one, but not the second one.
well, and Ms. Dukes, the fact that Ms. Dukes allegedly didn't tell Ms. Ridley about the case, I think is somewhat disingenuous. But be that as it may,
Well, that's why I said maybe, but you got to hit both numbers. So I'm not setting aside the default. Let's make that clear.
So at this point, what my client would prefer is that the court simply sign the order of eviction. The tenants then can either move voluntarily or involuntarily, and my client can go ahead and rent the unit out to somebody who will pay regularly.
Okay, all right. Ladies, anything to say?
Yes. May I comment,
Go ahead.
Judge?
Yeah, go ahead.
Okay. Okay. When I moved in, I was on medical. I had just had surgery. And I admit it has been a struggle. I've had an extreme amount of instances going on. I have had the money, but it kept increasing every time I tried to pay it. Miss Ridley is my childhood bestie, and I had just come through an ugly divorce, and she signed me up for this in order to start me over. So my apologies. It is my fault that she did not know, because I was trying to clear it up by myself. I was trying to handle it by myself and get back on track. If I am granted another chance, I will never be late again, because I am in a better place now. But it's just been a whole lot, all the way down to any minute I could get notice that my mother has passed away. So I have had, it's been extreme, Your Honor, and my apologies, and I have expressed these things to Desiree as well. But I'm trying. I'm trying. And I'm just trying to start over. So that's what's going on with me. I'm trying to start over.
Okay. Okay. Thank you, ma'am. And good luck with your mother. Ms. Ridley, anything you want to tell me?
Yes. And I didn't know Lisa is correct in the fact that she didn't tell me, but that I do believe when she says that at this point, because she has had a lot of health issues prior to that, everything will work out, and I'll ensure on my end to stay on top of things if she's granted to be able to continue, and we're able to stay on the lease, that there will be no more late payments as well.
All right. Thank you, ladies. Mr. Lamb, anything else from Plano?
Your Honor, all that I would say is that my client has 5 pages of notes going back to the inception of the tenancy in April. And we've heard these kind of promises before, and there has not been an action to meet the words. That's the best I can say.
Yeah, understood. Then they should have filed a termination of tenancy. They didn't. So writ will issue on or after December 4th if the judgment amount has not been paid. Ladies, understand?
Can I have clarification? What does that mean?
That means you've got until December 4th to pay $6,324.37, or they're going to proceed with the eviction.
Okay, Judge, I have a question. So a month's rent was paid towards that. So does that figure in? Does that come off or what?
When did you make the payment? How much was the payment?
Chris?
When we filed on that date for the 11/50. So
All
was
right,
it
11/50 was paid, and what date?
What date did we file?
Your Honor, if I
think-
may, the timestamp on the motion that our client received was October 18th.
Okay.
And
Thank
it
you.
does note on the order to stay the eviction that 1 month's rent was deposited with the court.
Oh, okay. All right, Ms. Ridley, you paid the court that 11/50.
Yes.
Okay, yes, then that 11/50 would be credited towards the $6,300 judgment amount. Agreed, Mr. Landman?
Agreed, Your Honor, and the order that I will submit will so indicate.
Thank you, Mr. Landman. I appreciate that. Good luck, ladies.
Thank you.
All right. Thank you very
Thank you, Your Honor.
much.
You're welcome. You're welcome. Gentlemen, are we ready to read that order?
Yes, Your Honor.
Go ahead. Listen close, Mr. Tyler.
So, Your Honor, we would propose to enter the following order. Item 1, defendant's motion to set aside default judgment is granted. Item number 2, defendant has until December 21st, 2023 to initiate arbitration and show proof of same, or this matter shall continue.
Pretty clear cut. Clear enough? Okay.
I've got 2 more.
Go ahead.
Number 3, if defendant initiates arbitration pursuant to the credit card agreement, this case shall be stayed pending the outcome of arbitration. Which I think is what we all agree to.
I think so.
And
So
then
far, so
lastly-
good?
Yeah, I have to look at my motion.
I believe that comports with your ruling, Ron. And then finally, Your Honor, if this matter continues, discovery is ordered through January 21st, 2024, and the court shall set a pretrial hearing thereafter. Which again is exactly what I think you ordered.
All right, Mr. Tyler, you're confusing me. You're looking at that paperwork, and I want you to know if you agree with the terms of that.
I don't know. I'm sorry for the motion. What do you say again?
Your Honor, I think you,
Have you read that? Did you show him a copy of it?
it's my handwriting.
Read it again. Read your bullet
From the
points.
beginning? From the
No,
top?
I heard the majority of it's the last part.
I think it was number 3 where we lost track of each other. So number 3, if defendant initiates arbitration pursuant to the credit card agreement, this case shall be stayed pending the outcome of arbitration.
Agreed with all those terms?
That's agreed, but I guess I object to the fact that I'm the one who's supposed to initiate.
You don't have to agree with my order. You
Okay,
just have to
yeah, I
understand.
agree. Yeah, I understand.
I mean, you agree that that is what I ordered.
That is agree with you.
Okay, the paperwork matches what I said.
Yes, yes.
Okay.
And then finally, item number 4, if this matter continues, discovery is ordered through January 21st, 2024, and the court shall set a pretrial hearing thereafter.
Okay.
Which is what I
Yep.
think you request.
All right, so you're gonna have somebody from the office submit that on base, or you want to just, I'll sign it now?
Your Honor, if I had a clean sheet of paper, I would, but this is on the back of one of my, it's a printed page. I can't give it to you because it's got. the notes.
That's all right. So he's gonna submit an order formally that
Okay.
matches those
You're
terms.
gonna submit a copy?
Yep,
Okay.
yep. Okay?
Okay, so I'm sorry, Your Honor, and I'm getting used to this new technology. We're referring to it as the on-base system?
Yeah, e-filing. So if you submit that on base, do you have Mr. Tyler's email?
Yeah.
All right, so you could email it to him.
You know what, may I get his email? Just so
I'm
we-
assuming he'll give it to you.
Yeah.
Yeah.
It's ICBEAL.
Now you can take it down. Miss Francis, we're gonna put Mr. Tyler in the Zoom room in just a minute.
Thank you, Judge.
Paper is cheap. It's okay if you wait data. So
Judge, I'm Judge, I don't know if we really need one. Plaintiff was.
I'm
just
sorry, Miss
gonna-
Francis, go ahead.
I don't know if we really need a breakout room, or if we should.
Okay.
just proceed with our motion.
Okay, go ahead. Give me the file name. Stay where you're at, Mr. Tyler.
Synchrony Bank versus Jermaine Tyler.
All right, and your appearance for Synchrony.
Navjot Francis, P72322 on behalf of plaintiff's
All right,
attorney
and
of record.
thank you. Mr. Tyler, you can hear her okay?
I can hear her.
All right, Ms. Francis, go ahead.
Your Honor, this is our motion for summary disposition. We did adjourn it previously to review Mr. Tyler's fraud claim. My client did review it and determined that there were payments, and the account was open for 2 years with charges, payments, even returns made on the credit card. So they determined that this was not a case of fraud. Also, the statements went to the same address where defendant still currently resides. So, Your Honor, all of this is indicative that this was Mr. Tyler's credit card and used by Mr. Tyler, payments made, and so we would ask for a motion to be granted.
Thank you. Mr. Tyler, your response.
She said that they reviewed the statements and that the payments were made. I guess I object to the information. I object.
What do you mean you object? You disagree with it?
I disagree.
Okay, well, that's different.
I disagree. Yeah, I
Okay.
disagree. I didn't really hear what she was saying because
Okay, I can ask her to repeat it.
yeah, actually repeat.
All right. Ms. Francis, if you would, repeat your argument again.
Your Honor, to our motion, we've attached multiple statements that show payments made over the ones attached show at least 8 months of payments made on the credit card, purchases made on the credit card, also returns made on the credit card, and statements went to the same address where defendant currently resides. This account was open for almost 2 years, during which time payments and charges were made, Your Honor. So that is not indicative of fraud in our opinion. And I believe the law shows and the documents show that our motion should be granted at this time. Sorry,
Did you hear
I
that?
kind of- yeah, okay. Yeah,
I kind of have a frog
Thank
in
you,
my
Ms.
throat. I
Francis.
apologize.
No, that's all right. He heard you.
Yeah,
Your response.
Thank you, Your Honor. Yeah, I have a letter from the state of Michigan where my ID, all my credentials and medical records were compromised, and somebody were using. I had to go down to the head office in Lansing, and there was an investigation into this, and it was determined that someone was using my ID. This is the letter. I did submit it to the court, and I submitted it to counsel. And I also have a medical record showing that all my medical records, there had been an FBI investigation into this matter. I don't know, there was multiple breaches that I was in, and I don't, like I say, I don't know where they come or how sophisticated criminals are at getting your information. I know that all these matters have put my life on hold. It have stopped me from employment. It have stopped me from getting credit from other places. These issues have been reported on my credit report, and it's just been hindering my life. And I've sent in proof with police reports, FTC affidavit, stating that all of these matters have been investigated, and I've also been disputing it with the creditors and asking them for their internal investigation or what they investigate. And they just send me back letters stating that they did investigation and they show that payments were made. Because payments were made don't mean that I made the payments. I don't know how sophisticated no criminals are. If they can go and copy my personal ID and they can get my social security cards or my social security number, I don't know if they had the card, and they can apply it and use different address or forward documents from my address. If I'm not aware of this, I don't know. But my thing is that I have proof in stating that that all this stuff was compromised. And there have been FBI investigations. I can't do an investigation no better than the FBI can. And this is documented right here showing that, so I submitted all these. I've submitted multiple police reports disputing these items because for the last 4 or 5 years, this stuff has been going on and it's just been holding my life up. I have not been able to get on with my life because of these issues.
Okay. Ms. Francis, a couple questions for you. You said you've got, I think you said 8 payments that have been made?
Your Honor, I believe more payments than that have been made. I was just stating that attached to our motion are at least 8 statements that show 8 payments being made on this account.
All right. And do the payment amounts coincide with the balance amounts on the statements? Does that question make sense?
Let me see if I can answer it. They are for more than what the minimum payment was supposed to be, Your Honor. It's for at least double what the minimum payment was requested on the statement.
Okay. And those statements were sent to the address that Mr. Tyler currently uses?
Correct. The Buckingham Drive address.
Okay. And I'm going to bet you have no record of where the payments came from.
It shows, sorry, I'm just looking for some.
Yeah, that's all right. Take your time.
I believe they were just online payments. But then there were also returns to the store that were credited as well that are not included in the payment amount I was stating, Your Honor. But there were other credits to the account by returns made to the Lowe's store as well, where purchases were also made. And that just is not usual of a fraud case where people would actually return items as well.
Right. Anything else? Mr.
No.
Tyler, I'm asking Mr. Tyler, Ms. Francis.
Yeah. Just for the record, like I say, I do have an adult son for a period. I didn't even check my mail at my house, like I said, because I really wasn't receiving mail. When I checked my credit report is when I was really made aware of a lot of these issues and stuff like that. But as far as how sophisticated a criminal is to go online or make a payment or forward information, like I say, it happened to me in multiple instances. It's not the first instance where they paying on it because I wasn't aware of these issues. I'm not gonna pay on something and then I don't have no knowledge of it, So like I say, I've shown the courts that my ID, my personal with the same address were compromised. They told me it was someone else's face on my ID, and the letter is right here. If you like me to post it, mention give it to you. This is from the state of Lansing, So there were internal investigations with the state about that. My medical records, all my credentials were all compromised in some type of breaches that may have occurred somewhere. I don't know where. It's just that it's been hindering my life, and that's all I've been trying to put my life back together from all this mess,
But it doesn't make sense that criminals would steal your identity and then make payments on your card.
It doesn't make sense, right? It doesn't make sense. But what I'm saying is, who know how sophisticated or how close someone is or around me that may have did it. What I'm saying is that I did. That's what I'm saying. Who know how sophisticated someone else is about these issues that I'm not aware of, especially on the day of online. You go online, anybody can go online, get your ID, fill out an application, submit something.
That's not my issue. I have no doubt that people can steal other people's identity.
Right, but I'm saying even make a payment, even make a payment.
Why would they?
Because if they got, I was a part of an ongoing fraud instance where people were using my information.
Okay.
So I'm saying that if these are same perpetrators that are perpetrating this fraud, maybe that was the reason why. I don't know why someone would do it. I don't know myself why someone would make.
I understand your arguments. I'm granting their motion.
What is their motion?
For summary disposition, which means there'll be a judgment entered.
Okay.
Thank you.
I object.
You can object.
Okay, but
that means you need to file an appeal.
Okay, well, all right, but I also have filed a motion I was here for a motion for arbitration with them.
Too late, I just entered a judgment.
But you didn't hear, you didn't, I considered the motion to me.
I'm entering the judgment. Counsel, submit your order.
Thank you, Your Honor.
Thank you. Michelle, what else you got?
We have a plaintiff and one defendant on 23-1650 George Brooks versus, there's three defendants.
Brooks
Misa
is the
Theon.
plaintiff?
Yes, George Brooks is the plaintiff. And then Mr. Mamet is here, but there's no defendant yet on that case. And then I don't know what Mr. Duquette is here for. Oh, 5761.
All right, I missed what you said because I'm talking to Malachi too. On Brooks.
Okay, sorry. I
Who's
have
here on
Mr. Brooks here, and then one of the defendants, Misa
Which is
Theon.
who?
Misa
Okay.
Theon.
And this was scheduled when? 9?
At 9:30.
Figure out what's scheduled for this. 9:30?
Mm-hmm.
All right.
Looks like it's a pretrial.
Pretrial? All right.
Yes.
Mr.
And one-
Brooks, can you hear me?
One of the defendants has an attorney, but they're not here.
Okay. Mr.
Yes.
Brooks, can you hear me?
Yes.
All right. This was scheduled at 9:30. I don't do anything until 10 o'clock as far as default. So we're going to see if the other defendants show up. Understood?
Yes, sir.
Okay. Just hang tight.
Thank you.
Mr. Mahmood, what are you here for?
Good morning, Your Honor. I'm here for Michigan First Credit Union. It's an objection of garnishment. It was scheduled for 9:45. Your clerk just let me know that you guys generally wait about a half hour. I do though have another hearing via Zoom at 10:30. So
It's bad scheduling then. So
I
I'll
couldn't
get
agree
to you
more.
as soon as the 30 minutes is up.
I
What case
appreciate
is
it, Your
that?
Honor.
What case is
Michigan
that?
First, Michigan First Credit Union.
Thank you.
Thank you, Judge.
Do you need the case number, Judge?
No, I don't like numbers. I like names.
Okay.
We got it. We got it.
Okay.
And that's a motion to set aside garnishment. All right, so that's all we got right now, Michelle?
Yeah, Mr. Duquette is on the Discover Bank versus Lloyd, but Mr. Lloyd's not here yet. And it was
Okay.
set at 9:30.
All right. Okay, thank you. Thank you, counsel.
Your Honor, I think I lost my audience. Your Honor, when we left off, you were allowing us to serve or file the approved order by e-file by on-base, and I did obtain Mr. Tyler's
Okay to sign.
email. So I think we're all set.
Thank you.
It was very good to see you.
Thank you. Same here, counsel.
Take care.
We'll get back to that. Whitney was the two ladies.
Yes.
No, writ will issue on or after, on or. Yep, yep.
I'm a stickler. Give me a comment on a dollar. So,
Gotcha.
The last time around, I was. That's why I gave the other one a motion. Because I can understand why it's sending a payment like once in a while, just so Dan doesn't start getting done letters and stuff like that. But ain't no criminal in the world gonna do that. I suspect that last time around. And then today, when it came in on the first case and stuff, I even brought my son's social security number. It don't match either. Just too easy. So can you pull up that Brooks case, see what the hell it's about? Oh, yeah. I hate that. Okay. Yep. See if you can find a complaint, so I know what the case is about. was complaining. That's what. Some of the. He told me the. It looks like they're fine with this. Okay, well, that's not three defendants. Michelle said there was three defendants.
That's what the docket says. Are you
Yeah,
looking
I
at
don't
the
have a
same one as
docket.
me?
I don't have a docket.
Oh,
I've got,
let me bring it to you. I'll bring it to you.
I don't even have a complaint in this file. Maisa Thune, can you hear me?
Good morning. Yes, I'm here.
How do you pronounce your last name?
June?
Chun?
Yes.
All right. Is your business name Send Shipping?
Yes.
And that's an LLC?
Yes.
All right. Do you have an attorney today?
That's why I was gonna ask if I don't have attorney today, but I want to get an attorney for the next time we meet, because me and George, we had an agreement that we
Okay,
were gonna fix.
stop. I don't want to get into the agreement because you can't represent the LLC in court.
No, I'm not. What I'm saying is, like, we were gonna solve
If you
this
talk
problem.
today, you're representing the LLC.
Okay,
If I
so
let
I'll
you
wait
talk on behalf of the company, you're representing the LLC, and I'm not letting you do that.
All right, thank you.
So, Mr. Brooks?
Yes.
All right, Mr. Brooks, I'm going to reschedule this case. Did you file against Send Shipping, or did you also file against another company?
Yeah, I filed against Send Shipping and Mr. Manson, who owned the company, and his principal with Maslan.
Okay, I can't understand you, sir.
Yes, I filed against another company, which Mr. Mazan work for.
Okay, what's the name of that company?
Maslan Shipping Company.
Okay, is
Maslan.
that all right? So Send Shipping and another company, you filed against both of them.
Yes.
Okay.
He's the owner of Send Shipping.
Okay, so you understand what I said? We're going to adjourn this matter?
Yes, sir.
Okay, you'll get a notice from the court.
Yes, sir.
All right, enjoy your day.
Thank you.
Make a note that the second defendant didn't show up as of 9:59. And if they do, we'll just tell them we had to adjourn.
Thank you, gentlemen. We'll send you notice for the new court date.
Thank you.
Did not show as a
9:59.
And then Judge, Mr. Duquette is on the Discover that was set at 9:30.
All right, we're trying to get back to the file list.
It was at 9:30. Yeah, so it's a default time.
Mr. Duquette, what file do you have?
Discover Bank versus David Lloyd, case number 225761 GC.
I'm sorry, give me again, plaintiff's name?
Discover Bank
Versus Lloyd.
Correct.
And what's scheduled today?
It's defendant's objection to a bank garnishment and motion for installment payments.
All right, and what time were you scheduled?
9:30.
And Mr. Lloyd didn't show up?
It appears to be the case.
All right, and this was his motion to set aside garnishment?
Correct. And motion for installment payments.
Well, his motion to set aside the garnishment's denied because he didn't show up. I'm assuming you object to the installments?
Yes.
Both motions denied. All right, both motions denied for his fail to appear.
Thank you, Your Honor.
Submit an order for us, please.
We sure will.
Thank you.
Have a happy Thanksgiving.
You as well. Hey, Michelle, what happened to, oh, it was Mr. Mahmood. Mr. Mahmood, you're on Michigan First, right?
That's correct, Judge.
All right, and we still haven't seen Mr. Ames. And this was his objections to garnishments?
That's correct.
Scheduled at 9:30?
9:45.
All right, we're gonna give him a few more minutes then.
Not a problem, Judge. Thank you.
Thank you.
Yeah, I don't like your wording though. Both motions from defendant denied. Both defendants' motions denied. And I'm okay if you just do a capital D apostrophe S, capital P apostrophe S. How is that possible?
Yes.
This is the only one we got.
Until 1 o'clock, if I have 1 o'clock more things, so I can review now. And note for civil. It's nice if I got a docket too, not just,
Yeah, because I think.
not just the clerks, yeah. So related items, where I get to actually look at that. All right, how do I figure out what's scheduled for today? Oh, it's here. That ordinance. Yeah. Was performed.
Yeah.
Back to written complaint. So, if this guy's a pretty frequent flyer, we get one JIS for that. Probably done with you. I can take care of this one because there's no documents I gotta deal with anything. And then I'll just let you know what I decided. All right. Appreciate you. And Al, you can note that one case that the other party in there can show up as a panel application.
candy canes and silver land.
Mr. Mahmood, on Michigan First, my clock says it's now 10:16. Still
Yes,
no
Judge.
Mr. Ames, motion denied.
Thank you, Judge. Will the court provide an order? Or would you let me submit one?
You submit one on base, we'll sign it, and get it out to you ASAP.
All right. Thank you very much, Judge. Have a great day.
You as well, sir.